My Lord, I had addressed HMRC's positive case. I was turning
errors of the Upper Tribunal.
Indeed, and rebuttal of my learned friend's arguments as well, although I can be much briefer on that. And the reason I can be briefer on my learned friend's submissions is that they essentially support the Upper Tribunal decision. There are a few additional arguments that I'll address briefly, just to mop everything up. But in terms of the Upper Tribunal errors, I plan to address them thematically in the way that they're set out in the skeleton. So it's fundamental errors of approach, then errors on the contractual construction, and then errors specifically concerning the BPRA, or the approach to BPRA. So turning first to the fundamental errors of approach, we identify at the skeleton at paragraphs 36 to 39 three errors in the reasoning of the Upper Tribunal, and I submit they're all errors of law. The first is proceeding on the assumption that the capital amount was OVL's money in some meaningful, substantive way. Second, failing to recognise the importance of the correct construction of clause 3.5 of the capital account deed. And then third, determining that a withdrawal by the co-op under 3.5.3 of the capital account deed would amount, or would effectively amount to the co-op acting under the terms of the guarantee. So I address each of those in turn. The first, the assumption that the capital amount was OVL's money. The Upper Tribunal proceeded throughout its analysis on the basis that that was the case. We set out in paragraph 36 the references to paragraphs 171, 173, 178, 208, 210, and 220 to 222. And it certainly seems that by saying it was OVL's money, the Upper Tribunal was saying that in some material, substantive way. It accorded far too much significance to that premise to simply be referring to the fact that OVL had legal title to the money.
Well, it didn't, did it? It's the bank's money.
Well, it's the bank's money, yes. Yes.
OVL had a legal title.
Legal title to the debt. Indeed, my lord, yes. But I think they're using it as shorthand for saying it's OVL's money in the sense...
You get into all sorts of knots if you talk about my money at the bank, because it's not my money.
Well, quite, my
lord.
money. Indeed, and that's, I mean, on one view, saying it's OVL's money is wrong simply for that reason. But to the extent that you give it a more generous construction and say they mean that they were entitled to the money, they seem to have been according that a real substance and materiality that in my submission, as I've already addressed you on, it simply doesn't have. Now, in my submission, that approach entailed two errors of law. The first is encapsulated in two paragraphs from the Upper Tribunal's decision. I don't propose to take you to them. I'll give you the references and read them out. But it's paragraph 221 first, where the Upper Tribunal said the capital amount was OVL's, quote, profit out of the development sum, which it chose to use by supporting the LLP in achieving a successful outcome to the project. And also at 210 of the Upper Tribunal decision, where it said HMRC's construction of clause 3.5.3 meant that, quote, a withdrawal under clause 3.5.3 would effectively amount to a gift to the LLP. Now, in my submission, that amounts to a fundamental misunderstanding or mischaracterization of the facts and the way that tax-structured finance works. Because what the Upper Tribunal seems to be doing is approaching the facts as if they somehow happened in stages. First, OVL receives the capital amount as its profit. Then OVL chooses to use it by supporting the LLP rather than making a gift to the LLP. But in my submission, that's obviously not what happened. Obviously, this structure is put in place all at one time, at the outset. And the capital account mechanism was included as part of the structure. This is not a question of OVL unilaterally choosing to use part of its profit in a particular way, or to make a gift to the LLP. The starting point of my submission for the analysis should be no more than that the LLP, OVL, Co-op and Blake's agreed to enter into the transaction that included the capital account mechanism, and the Upper Tribunal's task was to construe the relevant contracts and derive the legal effect of that mechanism, based on construing the terms of the documents that were entered into at the outset of the transaction. Now, second and related error of law is that by starting from the assumption that this was OVL's money in construing the contracts, and clause 3.5 in particular, that leads the Upper Tribunal astray. because it's clause 3.5 itself that determines the extent to which OVL could actually benefit from the capital amount. And you have my submissions that that question can only be determined by correctly construing the contract. But if you start, as the Upper Tribunal did, from the assumption that this is OVL's money, that's what leads the Upper Tribunal to say, well, HMRC's construction is contrary to the commercial realities, because it would involve them effectively making a gift to the LLP of 2 million. But in my submission, that's to put the cart before the horse. You can only arrive at a conclusion as to whether or something in the vernacular is OVL's money by actually construing the contract. You can't start by saying that it's OVL's money.
In short, you say OVL's entitled to the money. OVL's entitlement to the money is what clause 3.5 says it is.
Absolutely, yes. And you can't start with any other premise approaching those provisions. And in my submission, the Upper Tribunal clearly did. Just a note there, my lord. The Upper Tribunal's approach to the capital amount is in stark contrast to its approach to the licence fee, where in my submission it took exactly the right approach. The licence fee also involves, it's a slight difference, but it involves the money, the licence fee amount, going to OVL from the LLP and then coming back. Now that was paid as an element of the development sum, but the Upper Tribunal didn't proceed on the basis, well, this is OVL's money, and it's choosing to use it to pay it back to the LLP. In my submission, it took the right approach in relation to the licence fee amount and the wrong approach in relation to the capital amount. Second error of approach is failing to recognise the importance of the correct construction of clause 3.5 of the capital account deed. And that, again, in my submission, entails two failures on the part of the Upper Tribunal. The first is a general failure on the part of the Tribunal to recognise the importance of the correct construction of the capital account deed. Now, the Upper Tribunal said at 204, at the very start of its analysis, quote, "We consider there has been too much focus on the contractual construction argument by both the parties and the FTT."
Sorry, is that 204?
204, my lady, yes.
Sorry.
It's page 215, my lady, if that helps, of the core bundle. Now, pausing there, in my submission, that's quite a surprising comment from the Upper Tribunal, given the central importance it placed on the contractual analysis for issue 1, and also for the other constituent elements of the development sum.
Well, I think they explain what they mean by that at 208. They say that you must look at clause 3.5 in the context of the other contractual arrangements and their purposes, and that's where they go into this enforcement of guarantee law.
Well, my lord, if I may, they do go on to say, if I can, I think they're making a specific point about clause 3.5 and saying too much weight has been placed on it. Just to make good the point I was making a second ago, the contractual position is clearly central to their analysis of issue 1, as you touched on with Leonard Leader. It's also central to each of the other individual elements. So, licence fee at paragraph 230, IFA and promoter fees at 283, legal fees at 291 and 297, and then the residue at 355 to 356. But in my submission, given that they're according such significance to the contractual position, which I submit is entirely right, in my submission, it is peculiar and not consistent to then not seek to actually determine what the specific nature of the contractual rights that the LLP had acquired were. And in order to arrive at that, it did need to do an analysis of the contractual position. And perhaps leading into my Lord's comment, that in my submission, the second more specific failure was the failure to recognise the specific importance of clause 3.5.3. That's at 204, so the same paragraph, where the court said, and if I just read the quote, "We will consider the proper construction of the relevant contractual documents, but it's necessary to step back and ask why it is necessary to do this, given that clause 3.5.3 only covers one possible scenario, where the project would appear to be failing and where both the LLP and OVL would likely lose money. Under the other scenarios, namely those covered by 3.5.1 and 3.5.4, OVL retains the benefit of the capital amount, even if it has to wait for at least 3 years to withdraw it under clause 3.5.1. Furthermore, it's entitled to interest on the capital amount. Even if we were to conclude that under clause 3.5.3, OVL was not entitled to add any sums withdrawn to the developer loan or otherwise claim them from the LLP, we are left wondering why that answers any relevant question." Well, in my submission, that is well, you have my submission as to why it's a relevant question, but in my submission, the Upper Tribunal was not focused on the fact that if 3.5.3 means what HMRC says it means, it is not possible to say on day one that it's incurred on or in connection with the development. The final point, or the third error of approach, in my submission is the finding that withdrawals by the co-op under clause 3.5.3 amounted to the co-op acting under the terms of OVL's guarantee. And that, certainly to my reading, is pretty central to the Upper Tribunal's reasoning. So, for example, at 213, subparagraph 2 of the decision, the Tribunal says, withdrawal under clause 3.5.3 amounted to the co-op, quote, effectively calling on the guarantee and the legal charge over the capital account. And the clearest statement to that effect is in paragraph 215. Perhaps, probably, rather than me reading it out, it might be easiest just to go to that. It's tab 12, page 218, paragraph 215. If I could just ask you to read the whole of that paragraph.
Yes.
So a couple of quick initial points on that paragraph. First, that analysis is the main basis on which the Upper Tribunal sought to explain the different wording of 3.5.3 and 3.5.4. In effect, saying 3.5.3 are withdrawals under the guarantee, 3.5.4 are not. And that's why you have different provision in respect of the amount being added to the developer loan. If the Upper Tribunal's analysis about the guarantee and 3.5.3 being a withdrawal under the guarantee falls away, its explanation of the difference of the wording largely falls away as well. So it was a contractual claim under the developer loan that came about. So in my submission, there is a real tension there. What the Upper Tribunal is saying is, well, on a withdrawal under 3.5.3, OVL would have had a claim in restitution. Therefore, you don't need to provide in the contract that it gets an addition to the developer loan, but actually there isn't a claim in restitution. It's a claim in the contract.
You could possibly reconcile those by saying, yes, it gives rise to a claim in restitution, but the borrower and lender under the developer loan separately agreed that the way that should be recognised would be an increase in the developer loan.
Well, the difficulty in my submission with that would be there would be nothing providing in the capital account deed for the developer loan to increase by way of contract.
Indeed, but if you start with a proposition that there is some form of restitutionary remedy, or however, whatever legal label you apply to it, which would lead to some form of amount owing from the LLP to the developer, the two parties to that essentially could, presumably, contractually agree between themselves that the way they would recognise that would be through the mechanism of the developer loan.
It is, I suppose that is theoretically possible. I mean, my submission would be that what the parties have done is set out in the capital account deed, and if they had intended there to be an increase in the developer loan, they would have provided for it. In a sense, why would they, and perhaps it comes on to a point I'm going to make in a moment, but given they've turned their mind to the position of withdrawals, why would they then leave effectively to the vagaries of restitution, as far as the capital account deed is concerned, a claim arising? If they had intended there to be an increase in the developer loan, why would they not have simply provided for it in that agreement where they are providing for what happens when you make withdrawals from the capital?
One possibility is that the bank is not really interested in what the guarantor and the principal debtor agree between themselves, as long as it's not bound by it. So fine, you OVL and LLP go off and agree what you like, but don't expect us to be party to it.
But that wouldn't really explain then why do you specifically provide in the capital account deed for 3.5.4 to result in an increase in the loan.
I see that.
I mean, ultimately, my submission is the parties all turned their mind to it. They provided for it in 3.5.4, and that's the answer, really. Hypothetically, we might be able to say you could have created some restitutionary right which could then be crystallised in some other way. But fundamentally, we have a contract to which all the relevant people are a party, and in my submission, they exhaustively set out the position in relation to capital account. Sorry, I've just lost my place. Yes, so just turning back to that tension in the Upper Tribunal's reasoning, given that they didn't actually hold that there was a claim in restitution that arose, in my submission, their reasoning and their explanation of the difference in wording necessarily falls away, because they're predicating that difference on the existence of a claim in restitution, which they ultimately go on not to determine whether or not it exists. So you can't base your explanation for a difference in wording on something that you say, well, there might have been this claim, but we're actually not going to decide whether it's there or not. Right? There's no basis for that, for the way in which the Upper Tribunal seeks to explain the difference in wording. The next point in that regard is that in my submission, the Upper Tribunal's analysis of the interaction between clause 3.5.3 and the guarantee is wrong. They are different legal mechanisms. They both do operate to protect the co-op's position, but in my submission, they are legally distinct. And from that, it necessarily follows that the existence of the guarantee does not explain the difference in wording. Now, to make that point good, we do need to look at the guarantee, which we didn't look at in very much detail before lunch. So that's tab 9. It starts at page 219. Schedule 1 and Schedule 2 identify the guarantor as OVL and the customer as the LLP. Schedule 3 I also don't propose to go to, but that's the limit on the scope of the guarantee, and it's limited to the value of all of OVL's assets that are charged to the bank under Clause 15 of the co-op, or pursuant to Clause 15 of the co-op loan.
But that, you say you don't propose to go there, but that's maybe quite important.
Okay, my lady, we can very...
the realisable value of those assets.
Yes, so the guarantee is limited to the value of the assets in the accounts that have been charged. Including the capital account. Yes, absolutely, my lady. I'm not trying to shy away from that. I was trying to summarise it rather than perhaps go to the page. Page 214 is where the agreement starts. If I could ask you just to read clause 1.1, just the first bit of clause 1.1.
I may say so, it's in such small print it's hard to read.
I can zoom in, but I'm afraid you can't. Would it help if I read it?
No,
I'm very, very happy to. It's also not a very good photocopy, which is presumably a function of multiple hearings.
It's even worse once you've OCR'd it so that you can write it up on screen.
It might say anything if you've OCR'd it.
Fairly fictional. I think I get the drift.
If it mentions Disneyland, that's wrong. Well, perhaps is it easier if I read it out or yes? Okay. In consideration of the bank granting or continuing to grant time, credit, and/or banking or financial facilities or services to the customer, the guarantor, or each of them if more than one, hereby unconditionally guarantees and undertakes on demand in writing made from time to time, place emphasis on those words, to pay or satisfy all monies and liabilities for the time being due, owing, or incurred to the bank by the customer, so that's the LLP, whether actually or contingently, and whether solely or jointly with any other person, and whether as principal or surety, and whether or not the bank shall have been an original party to the relevant transaction or made demand on the customer, including. And then various provisions set out in the following subparagraphs. The OVL is guaranteeing all liabilities of the LLP, including contingent liabilities, but a claim under the guarantee requires the co-op to bring a demand in writing.
Okay. In that context, I did notice that clause 13.1 seems somewhat broader than that. It gives the bank freedom to, frankly, help itself without a written demand. Right, if I can read the text.
So I think that the difference there, my lady, if I may say, is incurred to the bank from or by the guarantor hereunder. Whereas the difference with clause 3.
Which may now or hereafter may become due.
Indeed, but under clause 3.5.3, all that's required is an event of default by the LLP. It's nothing to do. So this is aimed at the guarantor. Clause 3.5.3 is aimed or is triggered by events of default by the LLP.
Yes, I'm just pointing out that it says may now or hereafter may become due from the guarantor.
Yes, and it certainly covers contingent liabilities, that's for sure. That's in clause 1.1. But I do, just pausing, do place some reliance on the fact that it requires a demand in writing by the co-op. If we can skip forward to clause 9, it's a similar provision to what we saw in the charge. It's page 216. And if I just read that out, other securities and guarantee. This guarantee shall be in addition to and shall not in any way prejudice or be prejudiced by any other guarantee, including any guarantee signed by the guarantor, or any collateral or other security now or hereafter held by the bank for all or any part of the liabilities of the customer. And this guarantee may be enforced without the bank first taking any steps or proceedings against the customer or having recourse to any such guarantee or security. Now, I make the same submission that I did in respect of the charge that we looked at earlier. Guarantee is expressly additional security to any other existing security. Now, we saw under the co-op loan, it's clause 15.2, that the OVL's guarantee is secured by a list of charges and assignments, and that's including but not limited to the capital account. So there are basically charges over all of the various accounts that are set up under the structure. And there's a list given in the co-op loan. If it were to sit, my lady, if you would like to go to that.
No, I think we've seen that.
Okay, I'm grateful, my lady. Final point to make about the guarantee is a point the Upper Tribunal rightly recognised. It is a standard form contract issued by the bank. You can actually see on page 1 at the bottom, it's referred to as Form 375. And at various points, names are filled in. It's clear this is just their standard issue guarantee. And in my submission, that is in contrast to the capital account deed, which, as I've already submitted, is a bespoke agreement entered into between all parties. So having looked at those documents, I turn to make submissions on the basis that, in my submission, there is no basis for the Upper Tribunal conclusion that a withdrawal under 3.5.3 is a withdrawal made under the guarantee, such that the existence of the guarantee somehow explains the difference in wording between 3.5.3 and 3.5.4. So I make 4 points in that regard. The first is a preliminary point, really, concerning the objective intention of the parties. And it's a point I think, already covered, really. Because what we're saying here, the Upper Tribunal, at least in this context, in seeking to explain the difference in language between 3.5.3 and 3.5.4, is not really looking at the contractual position, as I've already submitted. It's really thinking about the position in restitution. And it's saying, because there's this other claim in restitution, we don't need to make provision for it in 3.5.3. That would obviously, as I've submitted, be a separate claim to the claim under the developer loan agreement. And so you'd have a situation where under 3.5.4, you'd have an amount added to the developer loan as a matter of contract. 3.4.3, you'd have a freestanding common law claim in restitution. Now, pausing there, the agreements relating to this structure run to several thousand pages. In my submission, it would be very surprising indeed, in fact, it's extraordinary, if the parties, having specifically addressed what the position was in relation to withdrawals from the capital account, then left the OVL's position in respect of 3.5.3 to the vagaries of restitution and unjust enrichment. As I've already submitted, I think the short answer is that's objectively not what the parties intended. They turned their minds to it in 3.5, and they made exhaustive provision as to what was going to happen. The second point of 4 is that clause 3.5 and the guarantee, in my submission, are separate ways in which co-op's position as lender is protected. Now, neither of those things is required by the other. You could have had the guarantee without clause 3.5. You could have had clause 3.5 without the guarantee. Neither is agreed pursuant to the So the Upper Tribunal rightly recognised in paragraph 183 sub 2 that in clause 3.5.3 there is no reference to OVL's guarantee as the basis for withdrawals under this clause. If they were really saying, well, it's all a restitutionary remedy under the guarantee, you would have thought there would be some mention of the guarantee. And it's notable that guarantee is a defined term in the capital account deed, but it's entirely missing from 3.5. Also, 3.5 and the guarantee don't need one another in order to operate. They can operate entirely independently of one another.
Can I just pause there?
Yes, of course, ma'am.
The charge in the capital account charge,
Yes,
that
ma'am.
explicitly supports the guarantee.
That's the capital account charge does, yes, Melanie.
Secures the guarantee.
Yes.
So I'm just trying to understand, we've got that document as well, which I'm not talking about. Are you saying that the charge effectively does sit with the guarantee?
Yes.
And that the capital account mechanism in the deed, capital account deed,
Is separate.
is separate?
Yes, so you've got the guarantee and the charge, which one would expect is a fairly routine thing for the bank to enter
But
into.
it is quite odd, isn't it? Because the mechanism by which the charge is enforced, I think you showed us earlier, is a release.
It is.
So precisely the same mechanism.
But to act under, well, that very neatly, my lady, takes me to my next point,
Okay.
which is that in order to act under the guarantee, the bank has to make a demand in writing. So we saw in clause 1.1, a claim under the guarantee requires a demand in writing.
Yes. So you say that would be needed to
Trigger,
pursue the charge.
yeah, well, to trigger the liability under the guarantee, which is secured by the charge. But importantly, 3.5.3 doesn't require a demand in writing. It just permits the co-op to withdraw the money directly. So neither action involves triggering the other one either. You can act under the guarantee without acting under 3.5.3. Equally, you can act under 3.5.3 without triggering the guarantee. In my submission, you can test it by acting what would be the difference if the guarantee didn't exist in respect of 3.5.3, and the answer is there'd be no difference at all. It could still operate in exactly the same way as, in my submission, it does work without the guarantee.
And without the charge.
And without the charge. My lady's right. In one sense, it does seem odd. But one might respond to that by saying it does seem a bit odd to pay £2 million up front to pay it into a blocked account that doesn't do anything for a number of years. These structures are thought about a great deal, and there is obviously detailed documentation put in place. And in my submission, one really does need to look at that documentation. And on that note, my submission, the Upper Tribunal seems to actually recognise at points in its decision that they are distinct mechanisms. So in paragraph 2094, when looking at the purpose of the capital account deed, the Upper Tribunal says, and I quote, its purpose was not to override the guarantee, rather it added to it by providing for withdrawals from the capital account outside of the guarantee, which would amount to a partial release of the co-op's security for the loan. So it seems to be sort of saying, well, it's outside the guarantee, but it's, in order to explain the wording of it, is inside the guarantee. And in my submission, that's an irresolvable tension in the decision. Also, just on that point, the logic of the Upper Tribunal's decision is that clause 3.5.4 withdrawals are definitely outside the guarantee, because that's the basis on which it explains the difference in wording. But merely by saying that, it's recognising that 3.5, in some sense, is a separate legal mechanism to the guarantee. So it's gone most of the way there of recognising there is this separate mechanism, but it's then sort of sought to say, well, actually, a bit of that mechanism is actually under the guarantee. And for the reasons I've just outlined in my submission, that is wrong. There is also in the passage that I just took the court to from the Upper Tribunal decision in 215, the statement that it's highly unlikely that the parties could have contemplated that the co-op had different routes against OVL, one under the guarantee and legal charge and the other under clause 3.5.3. Now, we've seen clause 9 of the guarantee saying that this guarantee is additional to any other security. So, in my submission, there's no reason in principle why it couldn't be, why clause 3.5 couldn't be in addition to the guarantee. And in my submission, you already have my submission that the co-op was in a position to seek the absolutely maximum protection it could possibly get. One may say it didn't need that protection. That may or may not be true, but there's no reason to assume it didn't take it, given that it could get it. And what you'd be left with is a standard guarantee issued by the bank, plus their bespoke capital account deed. Third and fourth arguments I can deal with pretty quickly. The third argument is that the Upper Tribunal and the LLP's argument would prove too much, because they seek to justify the difference in language between 3.5.3 and 3.5.4 by reference to the guarantee, on the basis that one relates to the guarantee and the other doesn't. You have my submission that it's not a withdrawal under the guarantee, but even if it were, there is nothing in the guarantee to distinguish between a 3.5.3 situation and a 3.5.4 situation.
So it can't be this patchwork that the UT thought there was.
Indeed.
Neither payment is within the guarantee, or both are, but the difference between the two can't be explained.
Yeah, and there's no bright line between the two. I'm grateful for it. And then the final point is a point, again, I've already made, but 3.6.2 of the capital account deed governs in any event, because we are dealing with withdrawals from the capital account, and 3.6.2 says they can only be made pursuant to the capital account deed. So ultimately, in my submission, all roads lead to the conclusion that you have to construe the capital account deed correctly, and that gives you the answer. A standard boilerplate guarantee issued by the bank cannot override that bespoke agreement that is clearly intended to regulate the operation of the capital account. So those are the three fundamental areas of approach. In my submission, each is without more sufficient to set aside the Upper Tribunal's decision on this aspect of the case. I do also need to look at the court's or the tribunal's errors as to the construction of the contract. I will try to be as quick as I can on that, my lord. Again, 4 errors. At least the length of the lists is familiar. The first error is the Upper Tribunal's reliance, we submit improperly, on pre-contractual materials or negotiating materials, specifically the information memorandum and the debt finance request. In my submission, it relied on those plainly in a legally impermissible manner. Second, the Upper Tribunal's textual analysis fails to account for any of the differences in wording between 3.5.3 and 3.5.4. Third, in my submission, its analysis of the commercial rationale is flawed. And then fourth, it misconstrued the developer loan agreement and the developer loan charge.
Misconstrued what?
The developer loan agreement and the developer loan charge.
Yeah.
Those final 2 points I've largely dealt with, so I can be very quick with those, but the first 2 I haven't. So as far as the first point, reliance on pre-contractual materials, we addressed that in paragraph 41 of the skeleton. It is absolutely clear that the Upper Tribunal placed very significant reliance on pre-contractual materials in construing the relevant contractual agreements, and particularly the capital account deed. So we can go to it, perhaps not read it now, but it's in tab 12, pages 206 to 208. It's paragraphs 170 and 171, where the tribunal looks at the debt finance request, and then 172 to 173, where it looks at the information memorandum. I would add that these documents are also relied on in Millennium Friend's skeleton at paragraphs 26 to 27, 30 and 43. Now, my submission, it is clear that the Upper Tribunal relied on those materials to support 2 of its conclusions. First, that the capital amount was OVL's money, again using the tribunal's words, while it sat in the capital account. And second, as to the correct construction of clause 3.5.3, and specifically the question of whether it led to amounts being added to the developer loan or withdrawals under that clause leading to additions. Now, in my submission, that is absolutely clear from both the Upper Tribunal's underlining of the quotations in 170 and 172. I don't propose to read them now, but perhaps I can leave you to read it, my lord. And also the Upper Tribunal's analysis in 171 and 173 that follows those quotations. The clearest example, just drawing it all together in one place, is probably 208 of the Upper Tribunal decision, where the tribunal says, and I quote, OVL decided to assist the LLP in relation to the funding from the co-op by guaranteeing the LLP's repayment of the co-op loan up to a maximum of 2 million, being the capital account. As was said in the debt finance request, this was done to give, quote, additional comfort to the co-op, which was already adequately secured by its charge over the property. This was spelled out further in the information memorandum, where the mechanism of the developer's capital account was explained. And then I place particular emphasis on the rest of this. in particular emphasising that this was not the LLP's money, it was OVL that had agreed to put £2 million of its money into the capital account, which would be charged to the co-op. Both documents made clear, both documents there being the debt finance request and the information memorandum, made clear that withdrawals from the capital account would be added to the developer loan, and the co-op was aware of this arrangement before it agreed to lend. Now, in my submission, you can draw an absolutely straight line from that statement and the tribunal's reliance on these pre-contractual materials to the Upper Tribunal's conclusions that the capital amount was OVL's money, and also as to the particular meaning and effect of clause 3.5.3. In particular, that withdrawals under that clause led to an addition to the developer loan. And I submit that that was an error of law for two reasons. First, an error of principle, because those pre-contractual materials were impermissible as an aid to contractual construction, and the Upper Tribunal was wrong in principle to rely on them. The court will, I'm sure, be aware of the Merthyr South Wales Limited decision. It's tab 55 of the authorities bundle. It's a decision of the Court of Appeal. If we perhaps turn it up, because there are a few paragraphs I'd like to quickly look at.
Which tab in the bundle?
Tab 55 of the authorities, which is...
Volume 3.
That's a really good question. Yes, volume 3, my lord. So, my lord, that was a case concerning a contract to establish an escrow fund for restoration costs that were going to be paid by a mining company. And the mining company wanted to rely in construing the contract on both its proposal for the escrow account and then the council's report on that proposal, which were clearly pre-contractual documents. And Lord Justice Leggett, as he then was, held that they were inadmissible to the question of construction. There's just two paragraphs before we get onto that particular analysis that I'd just like to point to. The first is paragraph 16 on page 1018. Just the start of that paragraph. In interpreting a clause in what is plainly a professionally drafted contract, it's appropriate to start by analysing the wording. Obviously a truism, but just Court of Appeal authority for that premise, or that principle. And then a few pages on at 1021, and this is just on the question of commerciality, paragraph 27, starting 4 lines down at the end of that line. It is salutary to recall that the persons best placed to judge what is a commercially sensible agreement to make are the parties who have chosen to make it, and courts should be correspondingly wary of rejecting a natural interpretation of contractual language because it appears to produce a commercially unreasonable result. Now, you have my submission here. The natural language points to what I would submit as a perfectly reasonable commercial result, but just some helpful principles there. As far as the analysis of the pre-contractual materials are concerned, that's at paragraphs 41 to 61. I would, again, commend the whole of that analysis to the court, but I don't propose that we read it now. The key, if I could ask the court just to read paragraphs 51 to 52, noting that 52 is the paragraph relied on by my learned friends, and then paragraph 54, so it's on those 2 pages, and then paragraph 61, which is on the next page.
51,
52, 54, and 61, my lord. So, my lord, if I can summarise it, 52 says what you can do and 54 says what you can't do. So looking at 52, previous documents may be looked at to show the surrounding circumstances and by that means to explain the commercial or business object of a contract. Note the distinction in the analysis between a provision and a contract. You can look at the overall circumstances to derive the purposes of the contract. But then 54, what is not permissible is to seek to rely on evidence of what was said during the course of pre-contractual negotiations for the purpose of drawing inferences about what the contract should be understood to mean. Now, my learned friends at paragraph 40 of their respondent skeleton submit that the information memorandum and the debt finance request were, quote, part of the factual matrix, and as such, the Upper Tribunal was perfectly entitled to take account of them, in effect relying on paragraph 52 of Murphy. Now, that may be correct if my learned friends and the Upper Tribunal were simply relying on those documents to show the surrounding circumstances and by that means to explain the commercial business object of the capital account deed. But in my submission, it's very clear when you read the decision that the Upper Tribunal relied on those documents for the purposes of drawing inferences about what the contract should be understood to mean. They are deriving the meaning of clause 3.5.3 directly from those pre-contractual documents. And in my submission, that is very clearly an error of law. So that's the argument from principle. There's also an argument on the particular facts of this case. Because in my submission, it would be wrong, I mean, even if you were allowed to draw on those documents for the purposes of identifying meaning, they wouldn't establish that meaning in this case anyway, because both of those documents, sort of clear from their names, were produced by the LLP and OVL for the purposes of discussing lending with the co-op. They are pre-contractual documents. They cannot possibly be said on the facts to record what was actually agreed with the co-op. And obviously what was actually agreed with the co-op is recorded in the capital account deed. So one has to construe that contract on the basis of what was agreed, not what one party to the negotiation said they wanted the agreements to mean. That's the first point. Second point is the fact that the textual analysis engaged in by the Upper Tribunal, in my submission, does not account for the differences between the provisions. And again, we've already touched on this to quite a considerable extent. The key difference is the absence of that provision to the effect that withdrawals will lead to an addition to the developer loan balance. And we saw that the Upper Tribunal's explanation for that really was its reliance on the guarantee, and you have my submissions on that. My submission, the Upper Tribunal also fails to explain the other two specific differences that I pointed to, the difference between the consents. Again, you have my submission, that points to a real difference in the effect of withdrawals under both provisions. And also, it has absolutely no answer. It does at least attempt to address the consents point at paragraph 214, but it has no answer at all to the reasonableness requirement placed on the co-op. The point is not even addressed in the Upper Tribunal decision. You have my submission that on HMRC's construction it makes perfect sense, but the Upper Tribunal identifies no explanation for its existence. And in the Upper Tribunal's eyes, as we know, 3.5.3 and 3.5.4 have identical effect. And in my submission, it's very difficult in those circumstances to see what the reasonableness requirement can be doing. Indeed, on the Upper Tribunal and my learned friends construction, in my submission, it's very difficult to see what 3.5.4 at all is doing. If clause 3.5.3 leads to an addition to the developer loan agreement, what's the need for 3.5.4? That there isn't really any. But on any view, there's no explanation.
Well, you might say that 3.5.3 is operated on the initiative of the co-op.
That is true,
and
yes.
3.5.4 is exercised on the initiative of the
you're making a
LLP. One of the consequences of exercising or of complying with the direction under 3.5.4 is that the co-op is reducing the amount of its security because of a limited recourse guarantee. So
but it is also reducing the loan by an equal amount.
It is reducing the loan, absolutely.
Yeah. No, so there may be a temporal point, I can see that, but on any view in my submission, there's no explanation for the reasonableness requirement because the temporal point would simply be addressed by saying, if we direct, the co-op to withdraw to cure this thing, then please withdraw it. There'd be no restriction on the co-op in how it operated. Now, the Upper Tribunal, in looking at those textual differences, said in paragraph 1.124 that HMRC's analysis, quote, reads too much into the differences in wording between 3.5.3 and 3.4. My learned friends refer to the points as semantic quibbles, but in my submission, that's not the case at all. What HMRC's case is doing is focusing on the objective meaning of the language which the parties have chosen to express their agreement in, directly in line with the enjoyment from the Supreme Court in Wood and Capita at paragraph 13. It's also important to remember that...
Which paragraph?
Sorry, Wood and Capita.
No, UT.
The Upper Tribunal, what, it's reference to reading too much into the wording?
Yes.
It's paragraph 124, my lady.
I don't think it is.
No.
It's not 1, 2, 4.
Oh, sorry, my lady. Let me find it. Oh, wait a sec. It's going to be, if that's going to be a typo, it's going to be 214, isn't it? Let me check.
Yeah, looks like it is 214.
Sorry, that's late night typing. I really apologise.
Thank you.
Yeah.
Yes, so in my submission, it's just according absolutely rightly the correct significance to the words that the parties have chosen to use. And in that context, it's important to remember that structured finance products of this kind are very carefully drafted and thought about a great deal, and a great deal of mental energy is put into these things. So when the FTT rightly held that it was professionally and no doubt carefully drafted in clear and unambiguous terms, it was right to do so. In my submission, HMRC are absolutely correct to seek a construction which gives coherent meaning to the words that the parties chose. And on that, it's only HMRC's construction in my submission that is consistent with and able to explain all the differences in language between the two provisions. And just one final point, the differences are not, they're not sort of nuanced, subtle differences that one has to get to through a thicket of definitions. It's absolutely plain on the face of the contract that this difference about an amount being added to the developer loan is there. You don't have to be a lawyer to recognise that. Anyone reading it would recognise it. So again, in my submission, that tells us the clear objective intention of the party. My Lord, on the commercial analysis, I think I've already perhaps done that quite a lot. The only point I did want to make was just in relation to the co-op, because there's a point that the Upper Tribunal specifically makes at 211, where it says even if, in line with the FTT's decision at 192, the reason for the different effects of 3.5.3 and 3.5.4 was to protect the co-op's position, there's no commercial explanation for the co-op agreeing to withdrawals under 3.5.4 leading to an increase in the developer loan. And then the Upper Tribunal went on at 216 to say, and again I'll read this out so you have it, quote, furthermore, if the co-op's purported commercial rationale was a desire to control the LLP's other liabilities, it's difficult to see why it would be more concerned about a clause 3.5.4 insolvency scenario than a clause 3.5.4 survival scenario. If the project was failing, it would be of no material relevance to the co-op what the LLP's other liabilities might be. It had the £2 million capital account, and the remaining £5 million was easily covered by its first legal charge over the hotel. It would surely be more concerned about other liabilities in the clause 3.5.4 situation, where there might in effect be a continuing struggle for survival. Now, my submission, and we address this in paragraph 44, the Upper Tribunal's analysis of the co-op's position is wrong in two respects. First of all, it fails to take account of the fact that the co-op was not required to comply with the direction from the LLP to make a withdrawal under 3.5.4. It had a power of veto subject to a requirement to act reasonably. And again, in my submission, it seems perfectly possible and sensible that the co-op may have considered that a power of reasonable veto was sufficient to protect its position in respect of withdrawals under 3.5.4. Second, in my submission, there is no basis for the Upper Tribunal's view that, quote, if the project was failing, it would be of no material relevance to the co-op what the LLP's other liabilities might be. The Upper Tribunal bases that on the fact that the remaining £5 million of the loan was, quote, easily covered by its first legal charge over the hotel. Now, obviously, that may be true in many situations. So, my learned leader referred to the Edward Simmons valuation of a completed and operational hotel. Now, there are three bases of valuation, and I don't propose to address my lord on trading potential again because we've done that once recently. But one of the valuations was a bricks and mortar valuation, business lost, franchise lost, nothing there, £8 million. So yes, on that basis, seemingly you would be covered as to the 5 million. But obviously that is not the worst case scenario from the co-op's perspective. There are very many potentially worse outcomes that could happen. One doesn't need to be too creative to come up with one. So the project could be left uncompleted. One might find, who knows, contaminated land in the course of doing the development. There are any number of things that could happen. So in my submission, it's perfectly possible that the value of whatever was left of the project could be less than 5 million. And it's possible that the existence of additional creditors of the LLP could affect the co-op's position. So now, one may get to the view that looking at it as a businessman, one might not regard these as things that necessarily require protection. That may be the view the court might take. But in my submission, it's perfectly sensible for the co-op to act and provide for a mechanism that ensures it has no exposure. It doesn't need to worry about this at all. The LLP's maximum exposure is what it's signed up to. It can't increase if the co-op is able to make a withdrawal under 3.5.3. That's the commercial side of things. Final point, again, the fact that the Upper Tribunal misconstrued the developer loan agreement and the developer loan charge. Now, clearly, what the Upper Tribunal decided was that what I've said was the recital to the developer loan agreement.
Well, I think we've been over this.
We have been over that, my lord, yes. The only point I'd make, and I think I perhaps have already made it, is that it is not, whereas on my learned friend's case, it is necessary to read in words withdrawals by the co-op.
No, you've made this.
It's not necessary on our construction. So that's the Upper Tribunal's errors. I very briefly deal with the points made by the additional points made by my learned friends. 3 additional points, as far as I can see from the skeleton. First is the views of the witnesses before the First Tribunal as to how the capital account deed was intended to operate. Second, the subsequent events, namely the fact that following a withdrawal of the capital amount, the developer loan did in fact increase by £2 million. And third, an alternative argument that if the LLP is wrong on the contractual construction and the Upper Tribunal is wrong, that a withdrawal under 3.5.3 would lead to a claim in restitution or unjust enrichment. I can deal with the first two very quickly. The witnesses, first of all, the witnesses' subjective evidence as to how contracts were intended to work are, in my submission, completely irrelevant to the question of the objective construction of the contracts. As far as subsequent events are concerned, they show us absolutely nothing because we do not know what clause the withdrawal was made under. And both parties agree that a withdrawal under 3.5.4 would lead to an increase in the developer loan amount. So the fact that that happened doesn't take us any further forward. Certainly doesn't tell us how you construe 3.5.3. As far as the claim in unjust enrichment is concerned, there are a few points that I'll make at this stage. The first point to make is that argument, if right, if that's the basis for the claim made by the LLP, that necessarily entails that the Upper Tribunal decision was based on an error of law. Because the Upper Tribunal specifically decided the case on the basis that on the correct construction of 3.5.3, there was an increase to the developer loan. And that's paragraphs 217 and 218 of the Upper Tribunal decision. That's the first point. If we're in that world, the Upper Tribunal is already wrong.
And, where does that get you? Suppose it was wrong and there is a claim in restitution. That doesn't help you, does it?
Well, it helps you, my lord, in that you're able to set aside the decision and remake it. I mean, we'd already be off to the races as far as... Oh, the point is that the Upper Tribunal decision couldn't stand. I mean, that's at least a helpful first step for my case, my lord. The second point to make is that the argument's not articulated in any detail at all. It is one sub-paragraph in my learned friend's skeleton argument, paragraph 42.3, and it was an argument that was actually raised for the first time in the Upper Tribunal, and we've seen the Upper Tribunal did not consider it in any detail at all. So to some extent, I'm going to need to see how my learned friend puts the point. But just to give you a couple of responses in principle, there is a first initial point, which might be a sort of a slightly academic point, but an interesting one nonetheless, that payment, in my submission, would not be made at OVL's expense, in circumstances where it has no beneficial entitlement to the money. And we know that the elements of a claim in unjust enrichment involve a payment at the expense of the payer here. Now, that's an initial point, and it might be more a point for a supervision than because we just don't have any authorities on the point. But in my submission, there is a complete answer to the point, which is the point I've already addressed my lord on. And that is the fact that the parties have agreed contractually, and in my submission exhaustively, as to the effect of withdrawals from the capital account. And given that, given you have a contract covering the field, in my submission, there is simply no space for a claim in unjust enrichment or restitution. And what such a claim would be doing would be rewriting the bargain that the parties had arrived at in the capital account deed. Now, what we have addressing the restitution argument is the recent chapter or the chapter 20 from the recent edition of Goff and Jones, which is sort of bang up to date. If I could perhaps take you to that, my lord, it's tab 60 of volume 3. Now, I wouldn't necessarily ask you to read the whole chapter, although it's obviously all very interesting and edifying. I would specifically rely on 5 paragraphs. So starting at 1373, if I could ask the court to read paragraphs 87 to 88, under the heading Ultimate Burden Properly Borne by Defendant. Then 92, which is over the page, and then 94. Well, 94 should be enough here. So 87 to 88, 92 and 94. And then I'll pick out a few passages that I'm placed reliance on. My lord, just flicking through those paragraphs quickly. 88, so on 1373. First, where the claimant and the defendant's relationship is governed by a contract that allocates responsibility for paying the third party, effect is usually given to this allocation. Over the page then at 92, if the court decides that the claimant should bear the whole of the burden, then his claim will fail. And then in 94, which is specifically, it talks about, I mean, it needs to be read in context to some extent, but it's talking about the different principles by which the court allocates responsibility. And the primary and first principle is this contractual allocation of responsibility. A claimant and defendant may agree that although they are both legally liable to a third party, one of them should ultimately bear some or all of the burden of paying him, and the others should not. The court will give effect to the parties' agreement by allowing a claim for contribution or reimbursement where some or all of the responsibility for paying the third party was undertaken by the defendant, and by the same token, the claim will be disallowed or reduced where some or all of this responsibility was undertaken by the claimant. And in my submission, that's exactly what HMRC say happened here. In the capital account deed, clause 3.5, the parties agreed, in the case of a 3.5.4 withdrawal, the LLP would ultimately bear the cost by way of addition to the developer loan. And in 3.5.3 withdrawal, OVL would ultimately bear the cost to the extent it had any meaningful beneficial interest in the amount in the capital account. And in my submission, that contractual agreement in the capital account deed is a complete answer to any claim in restitution by OVL. Perhaps that's why, in a sense, it was only raised for the first time in the Upper Tribunal and warrants only one subparagraph in my learned friend's skeleton. So in summary, in my submission, the Upper Tribunal's fundamental errors of approach and its errors of contractual construction are more than a sufficient basis for this court to set the Tribunal's decision aside. The additional arguments of the LLP provide no basis for remaking the decision in line with what the Upper Tribunal found. And on the basis of contractual construction alone, in my submission, this court should hold that the capital amount does not qualify for BPRA. I need to very, very quickly address you just on the errors the Upper Tribunal made in respect of the ancillary arguments for HMRC. I'm very conscious of time, both because of my Lord's indication and the fact that my juniors will, my co-juniors will be very cross if I take up any of their time, so I will definitely try and finish as quick as I can. As far as beneficial ownership or entitlement to the capital amount is concerned, you have all my submissions on that. The only point I would make is that the Upper Tribunal said at 221, we do not think the concept of beneficial ownership in this context, we do think that the concept of beneficial ownership in this context was not particularly helpful. And in my submission, what the Upper Tribunal was failing to do was to give the First Tribunal's decision the reading that I've suggested to you, namely that it was using that concept as a tool, and a tool that the First Tribunal was perfectly entitled and, in my submission, sensible to use. Also, a point that my Lord raised this morning, the Upper Tribunal appears to rely at paragraph 220 on the fact that interest was payable on the capital amount. And you have my submission, that doesn't alter the position because it's paid into the same loft account. As far as the circularity is concerned, we've heard that the First Tribunal found it was circular and self-cancelling. Upper Tribunal said, no, it wasn't. 2 points to make there. The first is that the Upper Tribunal says that the FTT seems to have thought by making that finding, or what it actually says is that it may have involved the FTT making a finding that the capital account was not expenditure incurred by the LLP. And it seems to say, well, that's the explanation of its finding in that regard. That's what the FTT meant. That's at 222 of the Upper Tribunal decision. It's also what my learned friends say at paragraph 45.3 of their skeleton, that circularity only goes to the question of whether expenditure was incurred. Now, in my submission, there's absolutely no basis for that, either on the FTT's decision or as a matter of more general law concerning capital allowances. You will have seen that the FTT had expressly held at the beginning of its decision in relation to an application to amend HMRC's statement of case that we weren't allowed to rely on incurred. It's inconceivable that it then later in its decision forgot that and decided, oh, well, we'll make a finding that they hadn't incurred the capital amount. That, in my submission, there's just no basis for reading the decision in that way. Moreover, it's absolutely clear from Tower and the Supreme Court's analysis there that questions of the circularity of payment are relevant to whether something is incurred on, and we say by extension in connection with, a particular end. I've already referred to Lord Walker's references to funds being, quote, put into a loop as part of a tax avoidance scheme. I actually got the references wrong. It was paragraph 78 and 75. But I would just submit, slightly treading on toes here, but the approach of the LLP in relation to this point is part of its wider failure to recognise that Tower was decided on the basis that it goes to what expenditure was incurred on. They have repeatedly sought to submit that Tower is a case about whether expenditure was incurred. It is absolutely clear that it is not. You only have to read Lord Walker's speech and also Lord Hope's speech. It's absolutely clear that they're saying when you decide what something has been incurred on, you have to look at all the facts. You take into account circular payment flows. You take into account valuation. You take into account, as you would expect, all the facts. You don't simply look at the agreement under which the amount has been paid and say, that's the end of it, we can't look any further. And they actually expressly criticise the approach of Mr. Justice Henderson, as he then was, in Tower, and they say that he had perhaps viewed the Capital Allowances Act as being Ramsey-proof in light of the BMBF decision. And they say, well, obviously that's not what that isn't what BMBF meant, and it's very clearly not what the Supreme Court say in Tower. It's about, you look, in determining what something has been incurred on, you look at all the facts. So in my submission, circularity is relevant to the question that was before the FTT. The FTT wasn't looking at a question of what had been incurred, and the Upper Tribunal was wrong to suggest anything to the contrary. Finally, you have my submission as to the Upper Tribunal's finding that this was not in reality circular or self-cancelling. In my submission, that's something the FTT was perfectly entitled to come to the conclusion of when it analysed the facts in a realistic way. So tying things up and hopefully putting a bow on them, my Lord, it's common ground that the capital amount was incurred on the 25th of March 2011 as part of the development sum. However, as a result, in particular, of the correct construction of clause 3.5.3 of the capital account deed, it is not possible to say on that date whether it was incurred on or in connection with the conversion, renovation or repair of Blush House. Instead, there was a real prospect that the capital amount could simply be withdrawn by the co-op in a manner that no benefit whatsoever would accrue to OVL from the sum. In my submission, it follows that that element of the development sum does not qualify for BPRA. Moreover, the capital account mechanism was a wholly artificial bolt-on to this transaction. You have my submissions that it had no commercial purpose, it was circular and self-cancelling, and in my submission it was included purely to increase the LLP's claim for BPRA. The FTT's decision that it was not qualifying expenditure was correct, and certainly one that it was entitled to arrive at on an orthodox application of the principles set out by the Supreme Court in Tower. And in contrast, the analysis of the Upper Tribunal involved a significant number of errors of law. On that basis, in my submission, this court should set aside the Upper Tribunal decision in respect of the capital amount, remake that decision on the basis that the capital amount does not qualify for BPRA. My Lord, if I might just briefly check that.
Yes.
My Lord, my ladies, unless I can assist further, those are my submissions on the capital amount.
Thank you very much.
Grateful, my Lord.
Right, who's next?
Yes, indeed. I'd like to address the court in relation to the Revenue's second ground of appeal.
This is the residual sum.
Well, it's a sum that's variously been labelled as the developer's fee or the developer's profit or the residual sum.
Yeah.
In the UT's decision, it's referred to at 342 as the residual amount / profit. The Revenue's overarching position on this topic can be stated shortly. The label does not matter. It's the substance of the item in question that does. Substantively, conceptually, what we're talking about in simple terms is the fact that OVL charged for what it did. That is to say, there was a profit element within the development sum that the LLP and OVL, or perhaps more precisely, Downing acting on behalf of the LLP in Canada, agreed would be paid to OVL in consideration of its services. Now, to be clear, there's nothing surprising or terribly exciting about the fact that OVL was not working pro bono. It's not in dispute that it was OVL, part of the CAMIC group, who put the project together. Upper Tribunal decision, paragraph 15. It's not in dispute that OVL was doing so in order to earn money. The FTT found expressly that, quotes, it was accepted by Mr. Lewis of Downing in evidence that CAMIC would earn a profit. That's First Tribunal decision, para 122. What does, however, require some attention is the question of how to analyse this profit arrangement and what flows from it in the particular circumstances of the present case, having regard to the particular statutory provision in question. Two tribunals have considered the point so far, and they've each come to a different conclusion. The FTT determined the point in the Revenue's favour. The FTT found that the item in question should be apportioned. The Upper Tribunal determined the matter in the LLP's favour, and so it is the Revenue who now appeals to this court. I'll say at the outset that I'm asking this court to consider the point of principle, i.e. whether there should be an apportionment in relation to OVL's fees. If you're not with me on that, that's the end of it. If you are with me on that, then I would ask that the matter be remitted to the FTT for the apportionment exercise, which is what the FTT itself envisaged in its decision in relation to this item. That's FTT para 231. In making my submissions, I want to start with two elementary propositions. Because it is elementary propositions that I say that this topic begins and ultimately ends with. Proposition number one. Sometimes it is appropriate to view a sum of money as comprising more than one component. One does not need to be in the Court of Appeal and surrounded by some of the finest legal minds in the country, to recognise the basic truth of that proposition. And let me give you a real life example, if I may. At the weekend, I went shopping with my daughter. While I dealt with an overly complex 6-person coffee order, I asked my daughter to go to the bookshop and buy a book that I needed. It was something important to do with cricket. I saw her head into the bookshop, and sometime later, rather longer than anticipated, she came out again. I could see that she was carrying a bag from the shop, and I could see that it was not empty. So far, so good. She then proceeded to wave a bookshop receipt at me. That also seemed positive. But on glancing at the bottom line figure on the receipt, I could see it was rather larger than expected. And on reflection, the bag rather heavier and bulkier than expected. And on close examination of the full receipt, I could see that in the fog of Hampstead Waterstones on a Saturday afternoon, the book singular had become the books plural. And the sum of money paid to Waterstones reflected the fact that it was in respect of more than one item. Now, in this case, Judge Brooks and Mr. D in the First Year Tribunal found that it was appropriate to analyse the development sum as being in respect of or comprising more than one item. Mr. Justice Green and Judge Scott in the Upper Tribunal were of the same view. And indeed, the LLP's own claim, the BPRA, as I said in opening, recognised, or at least appeared to recognise, that the development sum should or could be analysed as being in respect of more than one item. So that's my first basic proposition. Sometimes it is appropriate to view a sum of money as being in respect of or as comprising more than one element. Proposition number two. What is it that enables and makes appropriate when determining the object of someone's expenditure and an analysis that views a single sum as comprising more than one element? Well, putting it shortly, and perhaps truistically, it's relevant information. Or unpacking that slightly, it's knowledge, it's possession of information as to what the sum in question relates to and what, if any, rules apply to a particular situation. Now, if we think about the present context, BPRA, one can take a simple example. One might have an arrangement whereby a sum of money, say £100, is to be paid from A, the owner of a property, to B, painter and decorator, in respect of two things. Half of it is to buy a £50 tin of paint to be used to decorate the property. The other half is to buy a £50 bottle of champagne for A, which B is going to pick up on the way to the site. Now, the eagle-eyed might spot that one of those items might well qualify for BPRA, and one of those items might well not. And so in those circumstances, the correct analysis I would suggest would be that the amount claimed by way of BPRA is 50% of the total. £50, not £100. What happens then if the facts are slightly different, such that you know that the sum paid from A to B does not comprise two elements, one qualifying and one not, but three. One qualifying, let's say the paint, one not qualifying, let's say the champagne, and a third item being a specific sum that is agreed between A and B that B will charge for its services. So refining our example slightly, A gives B £150. A says to B that he or she can spend £50 on paint, £50 on champagne, and keep the remaining £50 for their trouble. What are the options in relation to that third element? I would suggest that there are three. Option one views it as entirely referable to, or part of, or to be analysed in the same way as the first element, the purchase of the paint. On that footing of the £150, 100 qualifies and 50 doesn't. Option 2, alternatively, one views it as entirely referable to, or part of, or to be analysed in the same way as the second element, the purchase of the champagne. On that footing of the 150, 50 qualifies and 100 doesn't. Option 3, one views it as partially referable to and to be analysed together with the first element, partially referable to and to be analysed together with the second element. Now, as to those options, I would make 2 points.
Isn't there an option 4? You don't analyse it at all. You just say that this was money given to your emissary for time and trouble, and what they choose to do with it's a matter for them. You asked them to buy the paint and the champagne, but you didn't ask them to do anything else with it, so they can do what they like with it.
But the question is what one does with it from the point of view of BPRA.
Well, I know that, but that's why these homely examples don't really help very much. I mean, if I give you £10 and say, go and buy me a sandwich and keep the change, you can do what you like with the change.
Well, Lord, it's not about the question of what's done with the money. It's a question about what you do, how you analyse a situation where you know that it was a specific element of an agreement, that the fee charged is referable to 2 items.
Well, I see that. If there is an obligation, which is where you were on your objection to the LLP's look at the development agreement alone, but then you've got to find an obligation.
Indeed, my
which
Lord.
relates to this residual sum.
Indeed.
Yeah.
Well, in relation to those options, though I hear what your Lordship says as to how useful or not useful they are, I would make 2 observations. The first one is that I do say that it would be peculiar, intuitively or as a matter of first principles, if in a case where A is paying a sum of money in return for getting more than one thing, and as a matter of analysis and law, one such thing is qualifying and one is not, then without more, the sum that B gets automatically attaches to the qualifying item, or automatically attaches to the non-qualifying item. I do say intuitively, logically, as a matter of policy, it's hard to see why that would be correct. If that observation is sound, then the question of the proper analysis of that third element will, and I hope this chimes with what your Lordship was alluding to, will, I suggest, be a fact-sensitive inquiry to be carried out on a case-by-case basis. So what is the possession if we turn to the present case?
Your approach does assume that the residual amount has the quality of a fee of some kind.
It does.
That you say, because there were a number of things provided, the fee has to be, in fact, must relate to all of those things, some of them being non-qualifying.
Well,
You have to characterise it as some sort of fee.
precisely so. And I don't say it's a matter of inference. I say that that is the case in this case, and I'll seek to make good that submission. Could we turn up the FTT decision, please? This is dealt with at paragraph 228 and following. So 228, we see the topic introduced. with the revenues contention. At 229, we see the LLP's responsive position, including counsel for the LLP's contention that the fact that Cannock made a profit does not call into question the quantum of expenditure on which BPRA is available. At 230, we see the revenue's counter-response. Davis says quite plainly, if we hold as we have, the elements of development sums are not allowable, profit by the developer should be apportioned. And then the second sentence there, the court will see those 4 items.
Yeah.
Then at 231, and we get the submission of the revenue at the end of 230 as to what flows from that. Accordingly, it's submitted that it necessarily follows that the profit should be apportioned by reference to the total price of that package. A penultimate sentence on page 354. Over the page, we have paragraph 231, where the tribunal agrees with that contention. We agree with Mr. Davey for the reasons he's outlined that there should be an apportionment in this case. Now, what is being recited at 231-4 is the foundation for the revenue's position on OVL's fee or profit element. The revenue's position being that there should be an apportionment. And while the FTT does not expressly state in the second sentence, paragraph 230, that it hereby makes the following findings, the following 4 findings, it is in my submission implicit and clear enough. That is what the FTT is doing. See at 231, we agree with Mr. Davey for the reasons he has outlined that there should be an apportionment in this case. And as it happens, before the FTT, the matters set out at FTT para 231-4 were largely common ground. And I'd like to go to one document, if I may. It's page 1023 in the supplemental bundle. That's physical bundle 4, tab 94.
(1023).
1023. It begins at 1022, or the front page is at 1022. So this is the LLP's document put in before the FTT in response to the revenues written closing submissions on the evidence and the law. And one sees the first page, as I say, at 1022, and then the relevant page for our purposes is 1023. If we look at the top 2 entries on that page, one sees 120A, that's a reference to the paragraph number of the relevant revenue document, and it's the quotation from it. Mr. Tracy agreed that the developer's profit related to an entire package put together for the appellant, and you see the LLP's position that none of this is disputed. And at 120B, next entry, one sees Mr. Lewis's evidence was that the notional total development price of 15.5 million was calculated by reference to a formula used on previous deals, whereby investors were charged a premium of circa 15% above the anticipated stabilised valuation of a mature business. You'll see that opposition is taken to the word notional, but otherwise, beginning of second paragraph in the column on the right, none of this is disputed. And if the court, I don't propose to go there, I'm very happy to if it would help, but if the court wants to see the paragraphs being responded to, it's one of the documents that's gone into the additional bundle that arrived at the court this morning, and it's page 74 of that bundle if one wants to see that document itself. And the reason that the LLP is very fairly taking that position, none of this is disputed, is because it was all firmly grounded in the evidence. I'd like to go to, within the same bundle, could we go to page 1014, please? Now, 1014 is a page within the revenues closing submissions, and you'll see the heading at the top, the developer's profit was referable in part to the acquisition of land. And you'll see the heading halfway down, the developer's profit was calculated by reference to a formula. And you'll see a number of evidential items cited. What I'm going to do is read out the references for those items within the current bundle, because the references there are from a previous bundle. If it's helpful, I'm happy to go to any or all of them, but equally, it may be that the court doesn't require that. So, just to give the references, say they're on the transcript. First of all, the reference to the heads of terms. That's paragraph 379. FTT decision, paragraph 50. Then 379A, supplemental bundle 4, tab 63, page 14. 379B.
So tab 63, page
14.
must be internal page 14. Tab 63, supplemental bundle.
Maybe a typo on my part. Maybe that someone can help me get the right reference to that if that's wrong.
Why don't you put them in writing and give it to us tomorrow morning? So we
Very
can
happy to do.
We will take it that these references are accurately summarised on page 101.
Yes, that is what I say.
Is there an obligation anywhere on the developer to procure the land? I know you say it's part of the package, but is there actually a legal obligation to do it anywhere?
Well, it's what is put to the investors in the information memorandum, that they're paying a total sum of 15.5 million, and in return for that, one thing they're getting is the freehold of the property.
Yes, but when you get to the development agreement, it talks about the works, and that those works do not include the acquisition of the land.
Correct, correct. So the position is that one has, I mean, I'm taking this out of order slightly, but if it's of assistance, what one has via those references that I've referred to, if one chases them through, is that it's accepted in evidence that what one has is, that is paragraph 84, Mr. Lewis's witness statement. What one has is what's called a
Cradle to grave.
Premium, well, it's cradle to grave, that's Mr. Tracy's wording. Admittedly, initially my wording, but he agrees with it. In Mr. Lewis's statement, it's paragraph 84, where the point is made that there's a 15% premium paid, and it's a premium paid on what's called the stabilised valuation. And the stabilised valuation for this purpose is the figure of 13.4 million, which is in the Edward-Simmons valuation. 15% on 13.4 million is just over 2 million, it's 2.1 million. In other words, the 13.4 plus the 2.1 gets one up almost exactly to the 15.5 million. Well, not quite exactly, there's a few $100,000 between it, but it gets one close to the 15.5 million, which is what's sold to the investors in the IM as the total package. So that's a little bit about how the numbers fit together there.
Yeah, so it's sold to the investors as a package, but there's no actual obligation to acquire the land. That's how I understood your answer to my question. Because if there is an obligation to acquire the land, I haven't seen it yet.
Yes, well, no, I understand the point that your lordship is making. The acquisition of the land is the very premise of the entire project, and it's factored in to the price that it's being sold for. So, we have the FTT's finding at 231, agreeing with the reasoning at 231 to 4. We say that that was common ground at first instance, and I've given the evidential references for it. And so against that backdrop, the FTT reached the conclusion that it did. Now, the UT disagreed with the FTT. We say that it shouldn't have done so. And I'd like to look at the UT decision. The UT addresses this issue at paragraph 342 and following. So, at paragraph 342, Upper Tribunal, the topic is introduced. At 343, the UT records the FTT's finding. Then at 344, they set out the
FTT said, yes.
Fully, 345 to 349, recording the party submissions. And then the analysis begins at 350. At 350, the UT refers to the FTT's acceptance of the building blocks of the revenues apportionment argument. And at 351, the UT says that this approach was wrong and was infected by the FTT's error of law in relation to issue 1. And then in the following paragraphs, it goes on to set out what it means by that. And sorry, my lord, just before I go further, I've been handed a note regarding obligation to purchase the land. A developer into creditor deed, clause 16.5.1.
That was about SLDT, wasn't it? Was it about the purchase of the land as well? Might have been.
Yeah, it is.
Purchase of the land.
5.1.
16.51.
Yeah.
But it's not, well, it's not part of the development sum. It's this isn't an amount. Is this an amount that goes to OVL? It doesn't say that. It's saying what's happening to the subscriber
money.
account.
It's directing how money is going to be used out of the subscriber's account.
And that's
That
LLP's
comprises
account.
that comprises the co-op loan plus the investor's money.
Yeah. So the investors, on the face of it, are paying for the property. The LLP is paying for the property.
Yes, the LLP is purchasing the property.
Yeah.
Our point is that the 15% premium.
No, I understand that.
Yeah.
My question was, is there an obligation on the developer to procure the property? We pointed to this clause, but it doesn't contain any such obligation. The developer is required, as I understand the intercreditor deed, to pay, or query to pay the stamp duty, 16.5.2a, that's possibly, I'm not sure who's paying that, probably the LLP as well. rest of it deals with the various accounts, some of which are in the name of OVL.
Yeah, I hear what your lordship says. So we were at 351.
Yes.
The UT's decision. They've said that the FT's position is infected by its error of law, same error of law as in relation to issue 1, and then they set out what they mean by that below. Essentially, there are 3 points being made, and of course, note we deal with this at paragraphs 59 to 65 of our section. First point is that the UT take the position that what was being referred to as the residual sum was not OVL's actual profit. That's UT para 352. And also revenue skeleton paragraph 60. Secondly, and relatedly, the UT's position is that analysing the developer's fee or residual sum as a mere mathematical difference reveals, so the argument runs, that the FTT was focusing or overly focusing on OVL's position rather than the LLP's position. That's Upper Tribunal decision, paras 354 to 355. And then thirdly, the UT's analysis includes the observation that the question is not whether the taxpayer made a good bargain, that point supposedly being that of the revenue in the FTT's position. That's paragraph 357. In my submission, and as we say in our skeleton, paragraphs 60 to 65, those points are not good points. Fundamental point to keep in mind is this. What are we doing here? As I said in introducing this topic, it's not about the label that one attaches to this element, whether it's the developer's fee or profit or residual sum or anything else. That's not what matters. What matters is the substantive question of what is under analysis. What are we trying to attach or not attach BPRA treatment to? And the answer is that what we're looking at is a fundamental element of the agreement between the parties, that it's a fee, which is the product of 15% premium that OVL charges, that the LLP is paying to OVL in consideration of its services, which include, yes, BPRA qualifying items, but also non-BPRA qualifying items. I've already given the reference to the witness statement of Mr. Nick Lewis, paragraph 85. Formula was, quotes, around 15% above the stabilised valuation. And I've given you the numbers that involves. The valuation is 13.4 million. It's 2.1 million on top of that, which takes one up to just shy of the 15.5 million set out in the information memorandum. Reference to the 15.5 million is page 361 in the supplemental bundle, bundle 2, tab 19, page 361. And the fact that it includes acquiring the property is also in the information memorandum, supplemental bundle 2, tab 19, page 363.
Well, what I mean seems to me, I'm speaking purely for myself, what the UT was doing was building on what it said, paragraphs 122 and 131, namely what the LLP got for its money was not simply the obligation to carry out the construction, but it also got a series of specific obligations in the intercreditor deed. And in answer to me this morning, you said that you thought that you agreed that that was right. That's exactly what the FT should have said. And then what they go on to say at 355, in discussing the residual sum, is that the LLP got these discrete rights obligations as set out in the intercreditor deed. They say it again at 356. That's what they deal with in terms of what the LLP got for its money. But the rest of it, they say, is, well, it's just part of the development sum for for the works. That's just part of the consideration for the works.
Well-
It's not the subject of any discrete obligation, which is why I asked you, was there a discrete obligation on the part of the developer to acquire the land? So far, you haven't been able to show me one.
Well, what they say from 355 in relation to this item, final sentence, it was not a right or asset acquired by the LLP at all. But with respect to what the Upper Tribunal says there, although of course in a sense that is true, I do say it misses the point. It's logically flawed to analyse the position in that way in this context. It is the payment of the fee which means that OVL is going to provide the various services, some qualifying and some not. Of course it's true that in one sense it was not a right or asset acquired, but it's because the fee is paid that they get the services. And my case is that the services were a mixed bag. Some of them qualified and some of them didn't. And that's where we come back to, I do say ultimately, a fairly simple logical point. What do you do if you know that a fee is referable to more than one thing, and you know that one of those things qualifies and one of them doesn't? Do you lump it all in with one? Do you lump it all in with the other? Or do you apportion? I do say in the end, it really does come down to the nub of that point. The UT say it was not a right or asset acquired. Correct. But it's because the fee was paid that they got the right items, which the UT itself found partly qualified and partly didn't. What does one do in that circumstance? Does one say, yes, the fee's entirely BPRA qualifying, or no, it doesn't qualify at all, or in principle, does one portion?
Yeah.
The parting shot of the Upper Tribunal is at 357, where they raise the example of a taxpayer incurring expenditure of 100 to acquire a series of specific obligations which the supplier can discharge for 80. And in dismissing the revenues analysis, it observes that the question is not whether the taxpayer has made a good bargain or how the £20 should be allocated. I make 2 points about that. First, insofar as the Upper Tribunal is saying, 357, that it's not the right focus to inquire whether this is a good bargain, I don't disagree. That's never been the revenues case. Secondly, more importantly, the example that the Upper Tribunal gives is not relevantly analogous to the position in the present case. In the present case, the sum in question, the £20 in the Upper Tribunal's illustration, is specifically agreed by the parties to constitute the supplier's fee. It's not something which, as is apparently suggested in the Upper Tribunal's reasoning, is simply internal to the supplier, or an aspect which the payer is not concerned with. So that example, if I may say so, does appear to be out of kilter with what is salient about the present facts. Consider the following. Let's say we're in a world where instead of agreeing that OVL can keep a couple of million or so after specific constituent elements have been discharged in line with the intercreditor deed, OVL sends an invoice for its services for the LLP, who then pays this over separately. Now in that instance, it would seem to be, on the Upper Tribunal's analysis, that there'd be no problem with the principle of apportionment. It's money paid to the LLP, by the LLP to the developer, some of which is qualifying and some of which isn't. Why should it make a difference that, as in our case, the fee is incorporated within the development sum as a whole? I say there can be no principal basis for that difference of approach. So I do say the revenue's position on apportionment is logical, but it simply constitutes an exercise of characterising the fee paid to the developer so that the legislation can be applied to it. Now that's most of what I want to say. We've worked through what the Upper Tribunal says, and in doing so I think I have also dealt with the majority of the points made by the LLP in their submissions. That's LLP skeleton paragraphs 46 to 48. However, one point touched on by the LLP and not appearing in the Upper Tribunal decision is the Upper Tribunal decision in Cobalt. That is cited by the LLP for the proposition that the fact that a particular item of expenditure can be analysed as the developer's profit is irrelevant. That's LLP skeleton paragraph 48. And I'd like to spend a few minutes with Cobalt now. Could we go to Authorities Bundle, tab 57, page 1180. So Cobalt was an enterprise zone allowance case, and I appreciate that it will be familiar with at least one member of today's court. It's a long Upper Tribunal decision, but one thing which does not take up much space is the issue of developer profit. If we turn to paragraph 29, we get the issues arising. That's page 1191. And one will see that there are three issues. The first concerns the proper analysis of sums paid by the developer. The second is whether the LLP was acting with a view to profit. The third is whether the entirety of each capital sum was paid for the relevant interest within the meaning of the legislation. And that breaks down into subpoints, and the one that we are interested in is 293B. That's below little c on page 1192. The extent the developer's profit, if any, arises from the capital sums that comprise both qualifying and non-qualifying expenditure, should there be a reduction in the amount of qualifying expenditure on this basis? If so, what is the reduction? Issue 3 then starts at paragraph 190 of the decision. That's page 1226. Parties' cases start at 212 of the decision, 1232. And if we go to paragraph 212, please, that's on 1232.
212.
212, paragraph 212, on page 1232.
You said this part starts at which paragraph? This part you're referring to.
Sorry, I was just trying to give some context. So issue 3 starts at paragraph 190.
Thank you.
The parties' cases are then set out at 212 and following. And one can see that the submission being advanced by the revenue is, I think it's fair to say, a general submission. There's no suggestion of a specific formula. I'd be grateful if the court would read 213. It's quite a general, broad brush submission, if I can say that. At 227 to 242, the contractual arrangements are dealt with. Some aspects are dealt with specifically, but as far as I can see, the issue of profit is not. At 243 and following, there are the LLP's arguments. And then various topics are dealt with thereafter. Developer's profit is not dealt with, or at least not expressly, and not as far as I can see. Developer profit next makes an appearance at 284. And specifically within 284, it's 284 sub 4. So that's on page 1247. And I'd be grateful if the court would read 284 sub 4 on page 1247. Two points to make in relation to that. First of all, the court might notice within the formulation of that, there's the reference to it must follow that to the extent that any profit element the developer was built into the price. In other words, to the extent that it's not obvious at this point was subject to substantial, if any, scrutiny evidentially. And I say that contrasts with the present case. Second point, the point the UT is making in Cobalt, in my submission, is similar to the point the UT makes with its supplier analogy, UTD para 357 in our case. If I pay someone £100 to do something, and 80 is what it costs them to do it, without more, there's no basis to seek an apportionment of the difference.
Well, what the UT say in this paragraph doesn't meet your point. Your point is if you're paying a profit for more than one thing, one of which qualifies and one of which doesn't, then the profit must be taken to go, must be taken to be apportioned between the thing that qualifies and the thing that doesn't, where there is one obligation to provide a package of services.
Precisely so. It sounds like I need
that's
to labour the point further.
That's not what the UT is saying in the Cobalt case.
Correct.
Now, I don't know quite what the value of all this, the Cobalt decision is, since the decision itself is reversed. But there we are.
Indeed. Well, my lord, the reason I go to it is because it's cited by a learned friend. I should say, just for clarification, they refer to 2843. I think they mean 2844. And the court has my submissions on it. It's not our case. The application of a particular piece of legislation is always necessarily fact sensitive. Well, as I say, in this case, the FTT was presented with a substantial amount of factual evidence about the breadth and nature of the services, including fundamentally that the parties had agreed that developer remuneration, a 15% premium on the ES stabilised value, was to be paid in respect of a range of things, some qualifying and some not. That essentially is all I want to say. I simply say, stepping back, ultimately, the principle that in an appropriate case one apportions, I say, is inherent in the court's power in this area. It's a question of looking at the matters realistically, no more. And if one does that here, one sees that one has a fee which is partly referable to qualifying items and partly not. I don't say one needs it, but if it is of assistance or interest, if one wants a footing or a point of note in the case law, final sentence of Lord Hope's decision in Tower, paragraph 93, in the circumstances of this case, we can and should reach our own conclusion as to the amount that should be allowed in respect of the claimed expenditure. Now there the Supreme Court was considering that they had that power, the power of apportionment in relation to this Act, albeit a different section. And I would say there's no principled reason why the same wouldn't apply in this case in relation to the same Act.
Well, we certainly have the power to make any decision which the UT could have made if we find that they made an error of law, which requires us or entitles us to set it aside. Not quite sure what specific statutory power House of Lords stroke Supreme Court has, but no doubt they work that out for themselves.
I'm sure they did, my lord. In those circumstances, I would say that the UT was wrong to overturn the FDT's decision on the point, and accordingly, I would ask that this court upholds the Revenue's appeal on the point.
Right.
Unless I can insist further.
No, thank you very much. Right, who's up next?
My lord, my ladies, if I may, I'll make a start on the IFA and promoter fees.
Yes.
In terms of the skeletons, we deal with these in our appeal skeleton, paragraph 66 to 84. And they're dealt with in the LLP's response skeleton at paragraphs 53 to 68. We have two arguments in respect of the IFA and promoter fees. Our primary case, this is our appeal skeleton, paragraphs 67 to 75. Our primary case is that the IFA and promoter fees do not, on a proper construction of the legislation, answer to the statutory description of expenditure on or in connection with the renovation, conversion, or incidental repair to the property. That's our primary case. Our alternative case is that even if the fees can in principle qualify for BPRA, on the facts here, the fees are referable in part to non-qualifying expenditure, such as the acquisition of the land. And my submission is that the consequences of that are either the fees need to be apportioned so that only part qualifies. That's our appeal skeleton at paragraphs 67 to 83. Or the fees don't qualify at all. And that's our appeal skeleton, paragraph 84. I'll address you on HMRC's primary case first. In terms of the roadmap for my submissions, I'm going to do three things. First, set out HMRC's case positively. So develop the submission as to why, as a matter of the correct interpretation of the legislation, expenditure on IFA and promoter fees doesn't qualify for BPRA. Then, secondly, I'll address you on how the FTT and the UT dealt with the argument, and where, in my respectful submission, both tribunals went wrong in law. And then, thirdly, I'll address you on what the LLP says about the argument. So, starting off with HMRC's primary case, the starting point is to consider the legislation. And the court will have seen we're dealing with a particular type of capital allowances called business premises renovation allowances. And the court will also have seen that we have legislation that uses open-textured language, and in particular, it requires the court to consider whether expenditure has been incurred on or in connection with the conversion, renovation, or incidental repair of a qualifying building, and not on or in connection with a number of specific exclusions. The court will be aware that this is not the first time legislation has featured the words in connection with. There are a number of cases from a number of contexts in the authorities bundle. I'd like to go to one of them, if I may, which is the Barclays Bank case in the Court of Appeal, which is in the first volume of the authorities bundle, tab 32, page 353.
I've got McCarthy and Stone, tab 32.
I apologise, my lady.
HMRC and Barclays Bank PLC, tab 31.
Tab 30, that's, I think, the High Court decision. Tab 32 should be the Court of Appeal.
No, I've got a Court of Appeal.
Tab 31. In my
31.
bundle.
May, Arden, Scott Baker. All right.
Yes, that is correct, my lady. My apologies. That's my error. This is a case about pension schemes and whether certain payments were relevant benefits. And that turned on whether the payments had been made in connection with past service. I don't think we need to, but if the court wishes, we could look at the head note first. If not, I'll just move to the 4 or 5 relevant principles that I respectfully submit the court can take from this judgment. Principle 1 is that the expression "in connection with" can describe a range of links. The court must look closely at the surrounding words and the context of the legislative scheme to determine the extent of the link required by a particular provision. So I take that principle from paragraphs 18 to 19. Paragraph 18 begins at page 359. You can see here the second sentence, the expression to describe a range of links. Lady Justice Arden then notes that in the Coventry case, Lord Hope held that the court must look closely at the surrounding words and the context of the legislative scheme.
And in that case, they took quite a narrow view of what "in connection with" meant.
In Coventry.
In Coventry.
Yes. So, for your note, Coventry's in the bundle at tab 26. It's a ratings case where the question was whether the primary function of waste incineration premises was in connection with a scheme for the production, the sale of both electrical power and heat.
Yeah. And there, the emphasis was placed on the primary purpose of the facility.
Indeed. And as your lordship will see from the quotation at the top of page 360, Lord Hope noted in the Coventry case that the phrase is a protean one, which tends to draw its meaning from the words which surround it.
Yeah.
It's also a case in which Lord Hope described the wording "in connection with" as far from satisfactory. At paragraph 19 of the Barclays judgment, Lady Justice Arden notes, as she then was, that the relevant definition, so not just the word "in connection with," but the definition as a whole, and the surrounding provisions of the legislative scheme inform the court as to the extent of the link acquired by a particular provision. So that's the first principle I take from this case. The second principle is that the purpose of the legislation should guide the court's analysis of the meaning of the expression in the particular context. I take that from paragraph 30 at page 362. The third principle I take is that the question of what the expression "in connection with" means in the particular statutory context is a question of law. I take that from paragraph 31. Second sentence. The fourth principle I take from the same paragraph is that whether a payment is capable of satisfying the meaning is also a question of law.
Sorry, is that one again? Can you
So
say that one?
Principle 4 is whether a payment is capable of satisfying the meaning is a question of law. So I'm essentially taking two principles from the second sentence of paragraph 31.
Question of law with a very heavy fact component, isn't it? Must be I know it's not what Mary Arden says, but it must be. There must be a strong factual component to the question, isn't there?
Indeed, there's an Edwards and Bairstow flavour to what her ladyship says there. I take that from the following sentence. On the facts as found by him, there could be only one conclusion. The fifth principle.
But there presumably is a middle ground, is there? That facts are capable of satisfying the test, but the fact-finding tribunal decides they do not in fact do so.
Indeed, my lord. In that scenario, the question would be, has the relevant court or tribunal correctly construed in connection with in the statutory context? If the court or tribunal has, and we're into the situation that the lordship has put to me, then it would be a question back for the tribunal or court. The fifth principle is the question that my Lord Justice Lewison put to my learned leader this morning, which is about whether it's possible to have a connection with more than one thing. Lady Justice Arden addresses that at paragraph 20 in this judgment, which is at page 360. Obviously, the Barclays case is a very different statutory context. So what I'd like to do is seek to answer my Lord's question by reference to this particular statutory context, so the BPRA statutory context. And my submission is that the ultimate question for the court is whether the expenditure being analysed answers to the statutory description of qualifying expenditure, construed purposively. Now, it's certainly possible that a payment or an item of expenditure can have a connection with more than one thing. If one does get into that scenario, the next question would be, number one, whether the two connections coexist. Which may lead one to an apportionment analysis, or whether one excludes the other. And one example that may be on point in the present case is expenditure on the acquisition of land. So in the present case, there was expenditure on the acquisition of Lush House. The purpose of that expenditure was to convert, renovate, or incidentally repair the property. So there was a connection to the conversion or renovation. But there's also a connection to the specific statutory exclusion that says you can't have BPRA in respect of the acquisition of the land. So in that scenario, we would say that the non-qualifying connection excludes in its entirety the qualifying connection. So one can easily see how a non-qualifying connection can exclude the entirety of a qualifying connection. In my submission, it's less easy to see how a qualifying connection could exclude the entirety of a non-qualifying connection, unless the latter really is de minimis. Because Parliament has stated specifically that expenditure on or in connection with the acquisition of land can't qualify for BPRA. So if one has an item of expenditure that has a connection both with conversion, renovation, incidental repair, and with the acquisition of land, in my submission, it's difficult to see how BPRA could be claimed on the entirety of that expenditure without frustrating the intention of Parliament, which was specifically that you should not have BPRA on expenditure that's connected with the acquisition of land.
So that's an argument for apportionment, is it?
Yes. My point, my lord, is that where you have this situation where you have a connection, a qualifying connection and a non-qualifying connection, it's easy to see how the non-qualifying connection could exclude in its entirety the qualifying connection, but it doesn't go the other way.
Yeah.
Can I just make sure I've understood that? Because there was some discussion below, I think, about the in connection with concept being perhaps being similarly construed, both in the what's covered and what is specifically excluded. But I think you're saying something slightly different. I think you're saying, are you saying that if you're in the scope of the exclusion, then that removes the expenditure altogether, or that there's a sort of greater statutory pull towards the exclusion than the provision for relief?
I'm saying, my lady, two things. Number one, it's common ground, I think it's been common ground throughout, that in connection with is construed in the same way in both contexts. The second thing I'm saying is that if you have a situation where expenditure has a connection with something that's qualifying and non-qualifying, it can't qualify in its entirety. So that's the answer to my Lord Justice Lewison's query to my learned leader. I should say, though, in our submission, the particular items in dispute aren't items of expenditure which bear a relevant connection to two things. So my submission in relation to the IFA and promoter fees on my primary case is that they're too remote to the conversion or renovation to qualify. So it's not a situation in which those fees have a qualifying and a non-qualifying connection. Similarly, in relation to the fee that gets paid to Ramada, again, my submission will be it's too remote from the conversion or renovation to qualify. But in relation to my alternative case, one does get into questions connection to more than one thing.
Yeah.
So those are the 5 principles that I take from the Barclays case. The principles set out in the Barclays case and in Coventry have been applied in various cases which are summarised in the FTT's decision. Perhaps I should turn to those tomorrow.
Yes. If you've shown us the cases which establish the principles, are we going to be helped by looking at decisions which have very little precedential value in this court, applying those principles to different factual situations?
No,
I simply pose that question. It's up to you, of course, but you're
I have no
in line
intention
with
of taking you
what
through
I've already said about the large number of authorities.
Message received.
Thank you. 10:30 tomorrow.
All right.